Good morning. Let's see. Can you guys hear me?
Yes.
Good morning. How are you?
Morning. Great.
Good. Good morning, Catherine.
Good morning.
Happy Friday. Excuse me. I have allergies today. All right. Well, we'll go ahead and get started. All right. Glad to have you guys in the live class. All right. So I'll mute you guys and we'll get started. Here we go. Let's start off with some common words. Here we go. Ready? Ever, truly, bad, while, reply, able, might, care, appreciate, anything, went, call, money, yesterday, hand, making, month, still, look, done, friend, expect, even, pleased, case, writing, keep, thought, nothing, favor, regarding, both, something, getting, necessary, given, balance, line, answer, department, name, girl, enclosing, bed, therefore, mail, fact, instruction, heart, news, October, study, learn, returned, during, lot, city, pretty, future, weather, need, came, forward, certainly, men, above, trust, thanking, pleasure, sorry, written, years, past, stock, away, life, rather, material, paper, high, why, further, fine, really, desire, taken, through, suppose, new, seems, several, satisfactory, help, bill, understand, close, covering, guess, nurse, room, gold, sister, opinion, train, law, low. All right, let's go into some common phrases. You're going to phrase everything that you can. Here we go. I didn't believe. I didn't believe so. I don't believe. I don't believe so. I have believed. If he believed. If he believes. If I believe. If I believed. If you believe. If you believed. Must believe. Must have believed. Shall believe. She believed. She believes. Should believe. Should have believed. So he believed. So he believes. So I believe. So I believed. So you believe. So you believed. That he believed. That he believes. That I believe. That I believed. That you believe. That you believed. They believe. They believed. They have believed. To believe. To have believed. We believe. We believed. We have believed. What he believed. What he believes. What I believe. What I believed. What you believe. What you believed. When he believed. When he believes. When I believe. When I believed. When you believe. When you believed. All right. I'm going to read you a paragraph that focuses on phrases. You're going to hear, will you please, L-U-P. If you are, there are, on the, she will, we will, are you, that the, there is, you will, if you, up the, to the, we will. All right, so I'm going to read this once at 180, again at 200, and again at 225. Okay. Let me just date this. Here we go. She will be on the United flight that is due to arrive at 10 o'clock. We will arrive on the American Airlines flight at 7 o'clock. Are you planning to meet the planes? If you are, will you please be sure that the car is parked near the main gate? There are 4 suitcases, and there is also 1 large bag to pick up. You will save time if you pick up the bags first and then proceed to the flight deck. We will look forward to seeing you and your family and having a long and relaxing vacation with friends. Okay, so we'll do that again at 200. She will be on the United flight that is due to arrive at 10 o'clock. We will arrive on the American Airlines flight at 7 o'clock. Are you planning to meet the planes? If you are, will you please be sure that the car is parked near the main gate? There are 4 suitcases, and there is also 1 large bag to pick up. You will save time if you pick up the bags first and then proceed to the flight deck. We will look forward to seeing you and your family and having a long and relaxing vacation with friends. All right, so the last time will be at 2:25. Here we go. She will be on the United flight that is due to arrive at 10 o'clock. We will arrive on the American Airlines flight at 7 o'clock. Are you planning to meet the planes? If you are, will you please be sure that the car is parked near the main gate? There are 4 suitcases, and there is also 1 large bag to pick up. You will save time if you pick up the bags first and then proceed to the flight deck. We will look forward to seeing you and your family and having a long and relaxing vacation with friends. All right. My next drill focuses on word families that end with ing. So here are your words first. Suing, arresting, helping, testifying, calling, writing, telling, saying, losing, buying, driving, failing. Yep, that looks like it's it for the words. Here are your sentences. Jake is suing the company for damages. He is suing his wife for divorce. The arresting officer is present. He was in the process of arresting a suspect. Are you helping at the Friday night potluck? Stacy is helping to serve. After testifying, he left the courtroom. Are you testifying on Tuesday? Was he riding his bike? He was riding his motorcycle. They are saying he is guilty. Are you saying he is out of town? We have been calling her every day. They will be calling Mrs. Smith to testify. Was Sam telling the truth? I'm telling you the truth. He is losing the election. She is losing weight. Are you failing history? I am not failing any of my classes. Was Tom driving the car? My family is driving to the East Coast in August. He is buying a new car on Wednesday. Are you buying a house in the city or a house in the suburbs? All right, moving right to a number drill. This is going to focus on measurements, so I'm going to give you those before I read you the paragraph, okay? Or the sentences. Here we go. 6 3/4 inches, 52 feet, 9 inches, 8 1/8 inches, 17 feet, 2 inches, 4 1/2 feet, 729 feet, 9 1/4 feet, 718 feet. Okay, here is your paragraph. Ready? The boards were measured. Type A was 3 feet, 2 inches long. Type B was 6 feet, 4 inches long. Type C was 7 feet, 1 inch long. We then measured the steel pipes. 3 of them were 4 feet long with a diameter of 2.5 inches. 4 pipes were 5 feet long with a diameter of 13 1/4 inches. 5 of the pipes were 12 feet long with a diameter of 3 1/8 inches. In our order, we requested that all of the boards be at least 3 feet, 2 inches in length, and that the pipes be at least 4 feet, 2 inches long with a diameter of 2.5 inches or more. All right, so I'll read that one more time I'll read that at 200, okay? Here we go. The boards were measured. Type A was 3 feet, 2 inches long. Type B was 6 feet, 4 inches long. Type C was 7 feet, 1 inch long. We then measured the steel pipes. 3 of them were 4 feet long with a diameter of 2.5 inches. 4 pipes were 5 feet long with a diameter of 13 1/4 inches. 5 of the pipes were 12 feet long with a diameter of 3 1/8 inches. In our order, we requested that all the boards be at least 3 feet, 2 inches in length, and that the pipes be at least 4 feet, 2 inches long with a diameter of 2.5 inches or more. All right. You know what? I'll go ahead and read this again at 225, just for your practice, okay? Here we go. The boards were measured. Type A was 3 feet 2 inches long. Type B was 6 feet 4 inches long. Type C was 7 feet 1 inch long. We then measured the steel pipes. 3 of them were 4 feet long with a diameter of 2.5 inches. 4 pipes were 5 feet long with a diameter of 13 1/4 inches. 5 of the pipes were 12 feet long with a diameter of 3 1/8 inches. In our order, we requested that all of the boards be at least 3 feet 2 inches in length, and that the pipes be at least 4 feet 2 inches long with a diameter of 2.5 inches or more. All right. On to legal terms. And I'm going to do the same thing with this paragraph. I'll read it once for each speed. Okay, so you're going to hear complaint, double, instruments, tribunal, adjudication, notary public, which is initial N, final P, endorsement, authenticity, offense or offense, usually it's offense, jeopardy, backs, petition, declaration, documents, acknowledgement. All right, so the first time at 180. The complaint in a lawsuit may be referred to as a petition, a bill, or a declaration. Each charge in the complaint is known as a count. A court of law is also called a tribunal. The adjudication of a case takes place in a court of law. Double jeopardy means being tried for the same offense more than once. A notary public certifies the authenticity of documents and instruments. The endorsement is written on the back of a legal document. An acknowledgement usually appears at the bottom of a legal document. The cover for legal documents are called legal backs. All right, 200. The complaint in a lawsuit may be referred to as a petition, a bill, or a declaration. Each charge in the complaint is known as a count. A court of law is also called a tribunal. The adjudication of a case takes place in a court of law. Double jeopardy means being tried for the same offense more than once. A notary public certifies the authenticity of documents and instruments. The endorsement is written on the back of a legal instrument or document. An acknowledgement usually appears at the bottom of a legal document. The covers for legal documents are called legal backs. Okay, last time at 225. The complaint in a lawsuit may be referred to as a petition, a bill, or a declaration. Each charge in the complaint is known as a count. A court of law is also called a tribunal. The adjudication of a case takes place in a court of law. Double jeopardy means being tried for the same offense more than once. A notary public certifies the authenticity of documents and instruments. The endorsement is written on the back of a legal document. An acknowledgement usually appears at the bottom of a legal document. The covers for legal documents are called legal backs. Right. Give you some consonant compound doublets. Here we go. Sharp turn, gray barn, firm stride, slight smirk, bent twig, feeble cry, ground level, broad brim, furled flag, hard term, landscape, wheelchair, hard drive, flesh wound, green paint, short stack, bleached blonde, field crops, grand slam, wild stag, thick stew, strong brace, gold plate, stone step, steep climb, free press, cruise ship, heart trouble, small snack, steady grip, marked cards, great threat, grilled trout, basic trim, cheap shot, blue sky, brief stay, white clouds, dark brown, bridge span, black stripe, slow drip, blood stain, clear glass, snowstorm, frail child, clean pants, gray stripe, drop cord, thin blouse, cross stitch, double play, quick twist, cold spell, cruel sneer, smokestack, shrill squeal, warm breeze. All right. And my last drill are sentences that are focusing on final NT, final RD, final RB, final RMS. Here we go. It is apparent that you sent the rent. The ant ate the mint jelly. The runt is the brunt of jokes. Kay's tent pole was bent. The hint by the parent was to punt. The present talent hunt is conducted by Brent. Jay steered the Ford toward the guardrail. The third card was ordered and delivered to Pam Bard. The tattered coat was not altered. The battered woman said nothing mattered. Roy littered the yard. The hired man has the cord for the board. Did the barb disturb herb? The Serb lives near the suburb. Did the remarks perturb Lee or curb his temper? The farms have swarms of wasps. Some firms require performance norms. Are the dorms equipped with smoke alarms? All right. Moving right into literary. This is on the rights of the accused. Here we go. I'm going to start at 180, and then I'll work my way to 225, okay? Here we go. Although many courts are inefficient and render justice when is not always fair, or which is not always fair, in some cases which may be perceived as inefficient or unfair may in fact be due to the constant tension that exists between the public's demand for strict and quick administration of justice on the one hand and protections for the rights of defendants on the other. These protections stem primarily from Supreme Court interpretations of the United States Constitution. Many of the basic concepts about criminal justice are stated in the first 10 amendments to the United States Constitution, the Bill of Rights. All rights and privileges of the criminal defendant that the Bill of Rights contains may be referred to collectively as procedural due process. Although the Bill of Rights was originally intended as a limitation on the federal government, the court has now applied almost all of the Bill of Rights to the states. The law of criminal justice in the United States is a curious combination of state and federal law. Although each state is free to define what is a crime and to create its own court system and criminal procedure for processing the crimes through its courts, the state cannot go beyond certain limits set in the United States Constitution. These limits are set out in the Bill of Rights. The Fourth Amendment states, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause. The Supreme Court has interpreted the Fourth Amendment to mean that one is free from search unless the police have probable cause to believe that there is contraband or evidence of the suspected crime at the place to be searched. Suspicion of a crime is inadequate for search or arrest. Probable cause, that quantum of evidence that leads to a reasonable person to believe that guilt is more than a possibility, is the essential element. Evidence that is obtained in violation of the standards set out in the Fourth Amendment must be excluded from court. This rule is known as the exclusionary rule. The rule, however, does not prevent police from seizing evidence of unsuspected crimes during a legal search and using search evidence to bring additional charges. Among the Fifth Amendment's limitations on criminal justice is a provision that all felony charges be brought in the form of a grand jury indictment. The states are not constitutionally required to have grand juries, but about half of them do so. A grand jury is an official body of citizens brought together to decide whether a person accused of a crime should be officially charged. If the grand jury decides to officially charge, the charge is called an indictment. The purpose of the grand jury is to provide a barrier between the state law enforcement agencies and the individual. The Fifth Amendment protects a defendant from double jeopardy, being tried twice for the same offense. Once a person is found innocent of a charge, the prosecution cannot bring the same charge again. Nevertheless, the Supreme Court has recently ruled that a defendant can be charged with a different offense based on the conduct for which he or she has already been prosecuted. Perhaps the most famous clause in the Fifth Amendment provides that a person shall not be compelled in a criminal case to be a witness against himself or herself. This is called the privilege against self-incrimination. the defendant does not have to prove that he or she did not commit a crime. The defendant does not even have to talk about it or take the witness stand. Instead, the prosecutor has the burden of proving that the defendant is guilty. The United States Supreme Court has extended this privilege against self-incrimination to apply also to preliminary questioning by a police officer. Because this rule was established in a case called Miranda versus Arizona, the rights enumerated in that case are called Miranda rights. In general, prior to any questioning, a person must be advised that he or she has the right to remain silent, that any statement the person does make may be used against the person, and that the person has the right to to the presence of an attorney to be provided by the government if the accused cannot afford an attorney. Like evidence obtained in violation of the Fourth Amendment, evidence obtained in violation of Miranda under the Fifth Amendment must be excluded from the court under the exclusionary rule. The Sixth Amendment provides that in all, but in most minor criminal cases, the trial must be by an impartial jury. The defendant may, however, waive his or her right to trial by jury and be tried instead by the judge. Another clause in the Sixth Amendment states that the defendant has the right to be informed of the nature and cause of the accusation. An indictment or other charging instrument must contain precise technical language concerning the nature and cause of the accusation, because the defendant may only be tried on those offenses listed in the charging instrument. Therefore, evidence pertaining to any other offenses is usually not admissible during trial. The Sixth Amendment also states that in all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him. This clause gives a criminal defendant the right to be present in the courtroom at every stage of the trial. It also ensures the defendant the right to cross-examine those who testify against him or her. Finally, the Sixth Amendment gives a defendant the right to assistance of counsel for his or her defense. Although anyone who can afford a lawyer may hire one at any stage of a criminal proceeding, the Supreme Court has interpreted this clause to mean that even those who cannot afford an attorney have the right to one. The court has held that if a defendant is indigent, the judge must appoint an attorney to represent the defendant. Lying at the heart of this rule is the court's realization that without an attorney, a defendant's chances of having a fair trial are slim. The Supreme Court has also ruled that the criminal defendant has the right to effective assistance of counsel, and that if a defendant is convicted and the defense attorney's omissions or failures were sufficiently given, the conviction is not valid. The right to be represented by counsel is not limited to defendants who are tried for serious offenses. The Supreme Court has ruled that no person may be imprisoned for any offense, whether classified as petty, misdemeanor, or felony, unless he was represented by counsel at his trial. Therefore, if a person could go to prison, even for a day, as punishment for the offense with which he or she is charged, such person has the right to counsel. If, however, the maximum penalty is only a fine, the accused does not have the right to court-appointed lawyer. The Eighth Amendment forbids cruel and unusual punishment. Courts have had great difficulty defining this elusive term. After many years of verifying interpretations, it has come to mean punishment characterized by the unnecessary and wanton infliction of pain that is out of proportion to the crime. For example, in 1977, the Supreme Court ruled that the death penalty is out of proportion to the crime of rape, where no life is taken. In recent years, the Eighth Amendment has been raised frequently by prisoners filing lawsuits in which they complain that prison conditions are so appalling as to constitute cruel and unusual punishment. The Eighth Amendment also prohibits excessive fines. In 1993, the Supreme Court ruled that forfeitures of property owned by defendants convicted under federal drug laws are subject to the Eighth Amendment test against excessive fines. All right. How are we doing on time? 9:28, good. All right, I have an article here for you. This is called When a Crash is No Accident. Okay. So Southern California is ground zero for auto insurance fraud. I'm just stating this. All right. Here we go. Ready? I will read this at I'll read this at 180 because it's probably going to be a little challenging. Here we go. A trucker was traveling south on Interstate 405 in November 2015 when he encountered the bane of all Southern Californians, slow traffic. It was nothing unusual for a Wednesday leading up to rush hour until the Toyota Camry in front of the truck suddenly hit its brakes. The truck driver attempted to veer and instead crashed into the car before tipping over, but something was fishy. The evidence in all of the interviews indicated there was no reason for the Camry to have slammed on its brakes, said California Insurance Commissioner Dave Jones, describing what investigators later discovered was a staged accident designed to defraud the truck driver's insurance company. Two of the Camry's occupants subsequently admitted that they were part of a conspiracy. The tool job, as that crash came to be known because the truck was carrying tools, is one of hundreds of auto fraud cases the state investigates each year. The California Department of Insurance, known as CDI, employs approximately 300 detectives to investigate several types of fraud, and about a third of its resources is focused on auto insurance claims. Since 2001, the CDI's Urban Auto Fraud Task Force has teamed up with California Highway Patrol first responders and county-level district attorneys to catch and prosecute organized criminals making false insurance claims. In many states, including California, insurance companies are required to refer suspected fraud to the CDI. The Automobile Club of Southern California, for example, maintains a special investigative unit that looks into suspect claims using a variety of forensic tools to detect fraudulent activity. We have many success stories where we've confronted perpetrators about their scheme and they walk away from their claim because they were caught, says Jim Will, Vice President of Insurance Claims for the Auto Club. We also referred cases to local district attorneys for further investigation and prosecution when the evidence warrants it. Auto insurance fraud is a felony and the penalty could carry a significant fine, including jail time. Criminal intent. CDI Detective Sergeant Jose Solario was a supervisor with the task force that helped solve the tool job case. A 9-year CDI veteran, he is based in a non-descript office in South Los Angeles. We deal with creepy stuff, says Solario, who has been called in on cases when the CHP suspects foul play. When we make search warrant entries, we are finding a lot of illegal weapons. Auto fraud investigations is dangerous work because so much of the high value fraud involves staged crashes that often are perpetrated by known gang members. Through the task force, the state has arrested members of the local Bloods and Crips and the MS-13 Mexican Mafia. Still, anyone can commit fraud. The CDI has also collared grandmothers and Major League Baseball players. Whether perpetrated by those acting alone or by organized criminals, auto insurance fraud takes many forms, from exaggerated injuries and crash damage to fake thefts and backdated claims. Although individual auto insurance fraud is more common, the losses to insurance companies are far greater on a per-claim basis in fraud cases involving organized crime and its favorite tactic, staged accidents like the tool job. No way out. The so-called swoop and squat involves as many as 3 criminal vehicles targeting a single unsuspecting victim, often a distracted driver in a high-value or well-insured car or truck. 2 of the criminal vehicles box in the victim on both sides, preventing the driver from switching lanes when a car suddenly pulls directly in front of him and slams on his brakes, causing a crash. As Solario investigates a busy Los Angeles freeway, he scans the surrounding traffic with the mindset of the many criminals he's helped to catch. He's looking at where people are driving, what they are driving, and how. You will see people eating, fiddling with their music or phone, putting on their makeup, he says. Fraudsters like to target distracted drivers because they often didn't notice if their cars or if other cars start to box them in. Solario says a lot of swoop and squat crashes involve box trucks on highways with heavy truck traffic. As he passes a UPS truck, he notes that's a good target vehicle. Why? They have good insurance, so they've got deep pockets. Farther along the freeway, he points out a Mercedes. I also like this one. It's an expensive vehicle. The abundance of truck traffic and high-value vehicles are part of the reason auto insurance fraud is so prevalent in Southern California. Los Angeles, Riverside, San Bernardino, and San Diego counties accounted for about 60% of CDI prosecutions for organized auto fraud in the 2015-2016 fiscal year, totaling losses of $13.5 million. About 10% of the nation's insurance industry payouts are related to fraud, according to the Insurance Information Institute, and those losses are passed on to consumers in the form of higher premiums. Even if you're not personally a victim, you're still affected, Will says. Every consumer pays more for insurance because of fraud. And then now, the last part of this is how to avoid being scammed. The swoop and squat is the most common auto insurance scam. The Auto Club has these tips to help you avoid becoming a victim. Number 1, pay attention. You're an easier target if you're not aware. If you notice traffic slowing, look beyond the car in front of you to see if the situation developing is occurring on purpose. Number 2, don't tailgate. Typical staged accident schemers try to get drivers to rear end them because it's a no-brainer from a liability standpoint. If you hit a car from behind, you're likely to be at fault, so allow plenty of space between you and the car in front of you. Number 3, document the other car's occupants. Fraudsters will often exaggerate the number of passengers in the claimant's vehicle. You might rear end a car that has 2 occupants, but the claim could state 4 or 5. It's called a jump-in fraud, and each one of those persons might claim an injury. After a crash, count the number of people in the car and collect the names, driver's license numbers, and phone numbers at the scene. Number 4, take photos at the scene. In a staged accident or fraudulent, only minor damage may occur at the scene. However, the scammer may take his or her vehicle to a body shop that is on the scam and add damage to make it look even worse. Without a photo, it's harder to disprove foul play. And the last one, report fraud. If you suspect a scam or you know somebody who is committing fraud, call the National Insurance Crime Bureau at 1-800-835-6420. Tips often help lead to an arrest. And then my last part of this article is Q&A format, which is kind of nice. It's kind of funny. Last night I was marking this, and the background is black. So I was trying all these different markers to, get it to show up. And the only one that would show up is black. So go figure. I have a black Sharpie in here, but it's still, as long as the light hits it, I can see it, but it's, I'm definitely looking for it. All right. So this is the Q&A part of it. Okay. This is Q&A with the California Insurance Commissioner. Here we go. On a national scale, how does California or Southern California rank in terms of auto insurance fraud? Los Angeles is ground zero. In part, it has to do with the number of percentages of higher value vehicles here and the degree to which people in LA and Southern California use vehicles to get around. LA is also the hub of a number of major national interstates. There's a tremendous amount of truck traffic, and trucks can be targets. And then you also have organized gangs operating, other criminal enterprises that might decide to get into auto insurance fraud too. How do you catch perpetrators at fraud? The enforcement branch is the largest branch of the California Department of Insurance. Oftentimes people think of us as a consumer protection agency, but we're also a law enforcement agency. We have great partnerships with local law enforcement and auto insurers. Auto insurers, including the Auto Club, gives us referrals that helps us focus our investigations. How much auto insurance fraud occurs in the state? In the 2014-2015 fiscal year, we made 1,135,000 arrests and had 1,231 convictions. So let me say that again. My pen was in the way of that number. We made 1,135 arrests and had 1,231 convictions. The amount of chargeable fraud came to more than $17 million. What is the funding source of fraud prosecution? Policyholders. It's not taxpayers. Funds come from a statutorily set of fees of $1.50 per vehicle per year on auto insurance policies. How big a priority is preventing auto insurance fraud in California? We devote a great deal of attention to auto fraud, both internally and throughout the collaborations with the district attorneys, the DAs. In 2015-2016, we provided about $22 million in assistance to the DAs to prosecute auto fraud. that's a good share of the overall assistance we provide to the DAs for various types of fraud. Very interesting. I had no idea that that even existed, and I saw that last night and thought, wow, that'll be a good one to read to you guys. All right, so let's go into jury charge. How are we doing? Okay, we're doing good. The subject here is union complaint. I'm going to read this at 200. Okay. All right. Here we go. You are going to hear Larry Peck, Union, Board, District Court, Section 9H, United Electrical Workers, Section 10E, Hudson, Fur and Leather Workers Union, Hudson Manufacturing Company. You're going to hear contemporaneously. Contemporaneously. You're going to hear certiorari. Okay, certiorari. And I think that's about it. Affidavit. The Court of Appeals. All right, so I'm going to read this at 200. Okay. All right, here we go. This is a companion case to number 57, decided this day. International Fur and Leather Works Union filed a charge with the National Labor Relations Board alleging that Respondent Hudson Manufacturing Company had interfered with the guaranteed rights of its employees. This charge was filed in April 2006. A complaint was issued based on the charges in February 2007. At the hearing, Hudson sought to prove that certain affidavits filed by the officers of the union were false. The trial examiner ruled in accordance with the board's practice that the issue could not be litigated in the proceeding. The trial examiner recommended that an appropriate remedial order be issued to correct the unfair labor practice, which he found to exist. The board in general sustained the trial examiner and issued a remedial order against Hudson. Prior to this order, the board had been enjoined from taking administrative action requiring the union's officers to reaffirm their affidavits. In August 2008, an indictment was returned against Larry Peck, an officer of the union, charging that the affidavit which he filed with the board in August 30, 2005 was false. Peck was convicted for that offense. Thereafter, the board ordered the union to show cause why its compliance status under the act should not be altered unless Peck were removed from office. The union re-elected Peck as its president. Shortly thereafter, the board declared the union out of compliance with Section 9H. The union then obtained a preliminary injunction from the district court enjoining the board from altering or restricting the union's compliance status by reason of Peck's conviction. The Court of Appeals affirmed. The board sought to stay of the preliminary injunction pending decision by the Court of Appeals in the case of Larson versus United Electrical Workers. When the stay was denied, the board petitioned the court below pursuant to Section 10E of the Act for enforcement of the unfair labor practice order. Respondent Hudson Manufacturing Company moved for dismissal of the enforcement petition on the grounds of Peck's conviction for false filing under Section 9H. The union intervened and opposed the motion to dismiss. The court below granted the motion to dismiss, holding that since the falsity of the affidavit has been proved, the requirements of Section 9H had not been met and no benefit should be accorded to the union. As noted, the complaint in the unfair labor practice proceeding was issued in February 2007, more than 12 months after the affidavit of August 30, 2005. Section 9H provides that no investigation shall be made or complaint issued on behalf of a union unless there is on file with the board of a non-communist affidavit of each officer executed contemporaneously or within the preceding 12-month period. There was no charge against Peck for filing a false affidavit in 2005. The Court of Appeals met that difficulty by presuming that a person who was in this in 2005 continued as such through 2006 and through the critical date of February 2007 in absence of evidence showing a change in the factual situation. The petitioner has also urged that Peck's conviction for filing a false affidavit could form no basis for holding the union in decompliance prior to the affirmance of Peck's conviction on appeal. At the time of the decision below, Peck's appeal was pending in the Court of Appeals for the District of Columbia. As noted, we have granted certiorari to review the affirmance of his conviction. We conclude that the sole sanction of Section 9H is the criminal penalty imposed on the officer who files a false affidavit, not decompliance of the union, nor the withstanding of the benefits of the act that are granted once the specified officers file their Section 9H affidavits. Having so concluded, we find it unnecessary to reach the collateral phases of this controversy. All right. Let's go into Q&A. And I'm going to just start with strict Q&A, okay? All right, this will just be Q&A with the plaintiff, and it's just plaintiff questioning. Okay, and let's see here. What am I going to do here? What is it, 9:45? Okay, I'm going to start this at 180, and I'll work my way to 225, okay? All right, here we go. How close were you and Charles together? Approximately 2 or 3 feet. Had you gotten to the point where the transverse rod was at the time he began moving? No, I hadn't. Had you begun to move toward it? Yes, I just started to. So you weren't facing toward him at that time? No. Did Charles do anything in relation to Brian as Brian began to move? I honestly don't recall. Did Brian get past Charles? No, I don't think so. At the time when the hammer came into contact with him, do you know what position Brian's body was in? He was in sort of a running position or a jumping position. Was he moving quickly at the time? Yes, he was. Had he struck you in any way at that time? No, he had not. At the time when you struck Brian, were you intending to kill him? No, definitely not. What was the effect of that striking? It knocked him down. It stunned him a little bit. Did he fall immediately? Yes, he did. You did not have to push him down? No. Charles didn't have to push him down? No. Let's go back to where he's down. Where is he down on the floor? In the den. Where in comparison with what? With the wet bar. I'd say right over approximately by the corner of the pool table. In approximately the position where the body is outlined in red? Yes. Is that the exact position? No. After he was on the ground, what occurred? Charles grabbed his right arm, and I told Charles to hold him, and I'd go cut the cord, and we could tie him up. Did you do that? Yes, I cut the cord off of the transom, came back, and tied his hands and his feet. Did you yourself put any kind of gag in his mouth? I don't have any recollection of doing that, no. Did you take a piece of transverse rod cord and tie a gag in place or loop that around him? No, I did not. Did you see Charles do that? No, I did not. Were you watching to see whether he would have done that? Yes. At the moment while you were finishing the tying, was Charles gagging him? No, he was not. After you tied him up, what did you do next? I went up through the kitchen into the dining room area. Did you put any music on him or any wire on him? No, I did not. There appears to be a little piece of light blue cloth or rag that's tied around the right wrist. Do you see that on there? Yes, I do. Did you put that on? No, I did not. Do you know what purpose it serves? I have no idea. Showing you this photograph, plaintiff's D2. Do you see the transverse rod in the photograph? Yes, I do. Is that in the final position it was in as you were tying him up? Yes, I believe it is. All right, so again, I started at 180, worked my way to 225. Okay, this one is going to start with defense, and we do have the court and the plaintiff that that jumps in a little bit. Let me give you a short word list. You're going to hear Colorado Springs, Denver, Anderson, exterior, multiple, patio, realty, transaction, Pueblo, family, Stevens, pool, Leah, lawsuit, living, interior, garage, fireplace, winter, jacuzzi, swimming, summer. Okay. And again, this is going to be defense questioning. Here we go. And again, I'm going to do the same thing. Start at 180, work my way to 225. Now, we are here with regard to a lawsuit that basically arises out of the sale of some property that you owned in the Colorado Springs area. Right. First of all, do you recall the particular transaction that we are here about today? Yes. Okay. When was that sale? Oh, let me see. Approximately in 2007. Do you recall basically the month? I can't know. No, I don't remember. Do you remember whether it was in the summer or the fall, the winter? It was in the winter. And where was the property located? It was located in Colorado Springs. Do you remember what street it was on? Palm Road. Do you by chance remember the address? Yes, sir. What is that? 24991, no, 24993. Now, how long had you owned this particular property before you placed it up for sale? Approximately 4 years. And can you give me a basic description of the interior of the house? It was a 5-bedroom, 2-bath home. How many square feet did it have? Approximately 3,000. Did it have a garage? Yes, it did. And was it a 2-car or a, yes, it was a 3-car garage. Okay, 3-car garage. Did it have a family room and a living room? Yes, it had a living room and a family room. And did it have a fireplace? Yes, sir, 2 fireplaces. And as far as the exterior, were there any improvements such as a swimming pool or anything of that nature? Improvements were the patio cover, some brickwork in the backyard, a 38-foot pool, and a jacuzzi. Had you done that work yourself or did you have it contracted? I had it done myself. Who did you list the property with for sale? Greater Denver Realty. And was there any particular person that you listed it with? It was Leah Anderson. How did you come to list the property with Mrs. Anderson? I'm trying to think. Let's see. I believe Leah's card was left on our front door, and I also knew Leah through a friend that I went to school with. Okay, go ahead. I went to school with a friend who gave me Leah's card and number. We were able to reach her through her office. We bought our home through Leah. When we were ready to resell, we asked Leah for her assistance. I see. Do you remember what the purchase price of the residence was? $598,000 approximately. And what was the residence listed for at the time it was sold in 2007? I believe it was $475,000. And do you recall whether it was placed on a multiple? Yes. Listing? Yes, it was a multiple listing. How many days was the residence on the market before it was sold? 3 days. And what was the selling price, Mr. Stevens? Do you remember? $471,900 to be exact. We took a loss. All right. How are we doing on time? Good. Still have more time. All right. This is for voice. And it's a court transcript. Okay. So this is going to start with plaintiff, but the court's going to jump in. Here we go. I'm going to do the same thing. 180, work my way to 225. Can I call Cindy Netter? Mrs. Netter, please come forward. Would you raise your right hand, please? Do you solemnly state that the testimony you shall give in the matter now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God? I do, yes. Please be seated and state your first and last name for the record. My name is Cindy Netter. Okay, Mr. Anderson, thank you. Did you and Mr. Netter ever receive a check from his parents? Yes, we did. And do you recall when that was? Not the exact date. It was prior to purchasing our home in 2006. And the amount, do you recall what the amount was? $120,000. Who is that written out to? I believe Steve and myself. Your Honor, I have pre-marked some exhibits, so this ends up being exhibit number 14 on mine in every reference, and everything else, if we could mark things out of order. Marked for identification 14? Yes, 14, Your Honor. May I approach, Your Honor? Yes, you may. Exhibit 14. Would you take a look at that and describe it for me? It's a check from his parents made out to both Steve and myself for $120,000 signed by his father. And the date? It is 1/21/06. Is there a notation in the memo area or this area here? Yes, there is. And what does that say? Loan. Was that there when you signed it? I don't believe it was, no. Would you look at that? Does that appear to be Mr. Netter's handwriting? I object. That is within the personal knowledge of this. It is not. She has testified that the signature on the check was his signature. Mr. Anderson, can you lay a foundation concerning her? Sure. Have you ever seen Mr. Netter's signature before? Yes, I have. And his handwriting? Yes, I have. And does that appear to be his signature on the check? Yes, it does. Does that appear to be his handwriting where it has the names written on there? Yes, it does. Does it appear to be his handwriting where loan is written? It would be hard for me to say. A lot of the letters, take a look at there are 2 signatures on the back. Yes, there is. Do you recognize those? Yes, I do. And whose signatures are they? The top one is mine and the bottom one is Stephen's. Do you contend that this was a loan to the 2 of you? No, I do not. It never was intended as a loan. Not to my knowledge, no. I never discussed it with his parents. You never discussed the issue with his parents? What was it? A gift. Did you know it was coming? Yes, I did. How did you know it was coming? Steve told me. He said that they were giving you $120,000. That his father was, yes. Now, you know that we contend it was a loan. Do you know whether or not anything was paid as far as interest on this? Not to my knowledge. You never signed a check or paid any money? Not against this check, no. Not against this check. Did you ever pay any money? We had borrowed money from his mother later on, and we had returned it, paid it back. What was the amount? I don't know the exact amount. And when was that it was repaid? I believe it was sometime in 2008, probably around April or May of 2008. April or May of 2008, but you're saying that wasn't for payment on this loan? No, it wasn't. Not for this. No further questions on the issue, Your Honor. Ms. Hendrickson, thank you, Your Honor. Mrs. Netter, did you ever have any conversations with your husband regarding this particular $120,000 check? Are you referring to when we were getting it initially? Yes. At the time that you received the check, did you have any conversations with your husband about the check? Just the fact that his father was going to make us a gift. He was dying of cancer, and it was my understanding that he was giving the children gifts before he died. Did Mr. Netter ever tell you that this was a loan? No. Did in fact he tell you that this was a gift? Yes. Did he ever tell you that there was any written agreement regarding this as being a loan? No. Did you in fact use this money as a down payment on a home that you then purchased? Yes. Did you purchase this home under FHA government regulations? Yes, we did. And as part of that purchase, were you required to provide a gift letter to FHA regarding the characterization of this $120,000 check? Yes, we were. And did you and your husband indicate to the mortgage company that that was handling the loan, that this was in fact a gift? Yes, we did. And did your husband join in that information? Yes, he did. Now, you subsequently sold that home, didn't you? Yes, we did. And did you pay back any of this $120,000 amount at the time you sold the house? No, we did not. Did Mr. Netter, your ex-husband, ask you to pay back the amount to his parents? No, he did not. Was there any discussion regarding whether or not that should be? No, there wasn't. Did you then use the proceeds from the sale of the home to purchase another home? Yes, we did. Was there any discussion at the time you purchased the other home that this money should be used as a loan? No. In fact, there was never any discussions until the time of the divorce that would be a loan? Correct. I have no further questions, Your Honor. All right, Mr. Anderson, nothing further of this witness. All right, you may step down. Thank you, ma'am. Any further evidence, Mr. Anderson? Yes, Your Honor. I'll call the petitioner. Mr. Netter, please come forward. Please raise your right hand. Do you solemnly state that the testimony you shall give in the matter now pending before this court will be the truth, the whole truth, and nothing but the truth? So help you God. I do. Please be seated. Will you state your full name for the record? Stephen John Netter. Okay, go ahead, counsel. Thank you. Do you recall receiving a check for $120,000? Yes, I do. And do you remember approximately when that was? Approximately January 29th, a few days after. May I approach, Your Honor? Yes, you may. Showing you Exhibit 14, would you take a look at that? Is that the check that you received? Yes, it is. Do you recognize the writing on the face of that check? Yes, I do. And whose writing is that? That is my father's handwriting. And there's a notation that says loans on there. Is that correct? Yes. Is that his writing also? Yes, it is. Do you recall that being on the check when you received it? Absolutely. Can you tell me the circumstances surrounding the receipt of the check? Yes, my wife and I went back in November of '05. We informed my parents that we were in fact expecting a child. We said we wanted to buy a house. We asked for a loan and we discussed it at length with my parents. My dad was dying of cancer and he wanted to first. Let me stop you right there. Did he die? Yes, he did. When was that? It was April of 2006. Approximately how long after that check was written? Approximately 3 months. Okay, proceed. So what? He was dying of cancer and he wanted us. He didn't want us to give us the answer right away, of course. He wanted to check with finances that he, in fact, had. He did discuss it with both of my sisters and, his wife, my mom. And then they decided in January that they would give us the loan. And they specifically told us it was only a loan and it was for the benefit of my mom. And we discussed the terms and it was to be repaid to her because he knew he was dying. It was incurable cancer. What were the terms? Well, what my father wanted, it was a 3-year note payable at simple 5% interest to be paid back in one lump sum. And how were you supposed to come up with the money to pay that back? He suggested we either get a second or sell the house, or by that time, in 3 years, the real estate market would go up, hopefully, and we could make improvements on the house. Did you ever discuss this loan with the respondent? Absolutely. Has she said anything recently about it being about her recognizing that it was a loan? We did have telephone conversations during the inroads here. What did she say about it? She said that she did actually admit that my father did give us a loan, but she was not going to pay my mother back one red dime. Now, this was a loan. Was anything ever paid? Yes, it was. How much? We paid the $20,000 interest for the first 2 years that we did have the money. And when was that paid? It was paid in late May of 08, 2008. Yes, it was. And there are let me show you. I inadvertently have those unmarked if that would be possible. Just mark the originals. Hand them to me, please. I have 15 and 16 marked for identification. Thank you, Your Honor. Your Honor, counsel has not provided me with a copy yet of exhibit number 16. 15 and 16, I just handed her copies, Your Honor, representing that those are true and accurate copies of the exhibit. Would you take a look at, let's go to 16 first. Can you describe that exhibit? It's a letter. And who is it to? It's to my sister Diane. What is her last name? Diane Walker. And is it dated? Is the letter dated? Yes, it is. And who wrote the letter? I wrote the letter. Did you write it back when it was dated? Yes, on June 1st, 2008. How is it that you're in possession of it? I contacted my sister and she sent it back to me. Can you read it, Your Honor? Can he read it? It's only 2 pages. If I could have him read the letter. The letter is the best evidence, Mr. Anderson. We don't need to do that. Does the letter discuss a loan? Yes, it does. Does it discuss an enclosure of a check? Yes, it does. Does it say how much the check is for? Yes, it does. How much is the check? $11,030. Did you testify to the total amount of interest that was owed? Yes. At that time, the total amount of interest owed was $13,000. $13,000. So this is short of the $13,000? Yes, it is. Was there any other sum of money paid? Yes, there was either a cashier's or a certified check sent to my mother in the amount of $1,970, the difference. So $1,970 plus $11,030 makes the $13,000? Yes, it does. So why is that this check was written to your sister? Because at the time, my mom had owed my sister this amount of money, and she asked that I forward this amount to her. I'm going to show you Exhibit 15. Can you describe that? This is a check dated May 30th, 2008, made out to Diane Walker. And the amount? The amount is $11,030. Is that the check that was enclosed with this letter? Yes, sir, I believe it is. And is that on a joint account between the two of you, meaning the petitioner and the respondent? Yes. Who signed the check? Cindy Netter. Now, at this time, was there an agreement that the loan would continue, or was there any sort of a modification or anything? Yes, what we did was we needed the money to get into a new house. It was a brand new house and it needed improvements, needed the typical regular things for a new house. So we asked my mom to extend the terms of either modify the contract or extend the terms as to the $120,000. So we paid the interest payments and she agreed on the same terms of 3 years, 5% from the time the house escrow closed. When did the house close escrow? September 1st, 2008. So 3 years from now, it's already due, right? Do you consider this valid community debt? Yes, I do. Did your mother ever tell you that you didn't have to pay her back? No, never. No further questions on the issue, Your Honor. Cross-examination? Thank you, Your Honor. What is it? 10:04. All right. So that last, I would say the last half of that was all at 2:25. How did it feel, you guys?
Felt fast.
Yeah. Especially too when you're dealing with money, you know?
Yes. And just a long time to push at that speed, but that's good practice.
Yeah. Think of yourself as a runner and you're going on a long run preparing for the marathon. Yeah. Well, and what did you guys think about that literary article on the scamming, like cars, and isn't that amazing?
Yeah. So, first time you read it, I think when the pen was over your number was like 1 million something, and I was just, what? 1 million people? But no, even 1,000 or whatever it was, that's a lot of convictions for tricky.
Yeah, fraud. Well, and look at this picture here. I mean, these are just things that you don't even think about, but that's the picture that was in that magazine. Like they're showing you the scam, like the scammers. The red cars are the scammers and the blue is like the, like what we would be doing. And you just don't even think. I mean, I know that, there's insurance fraud, like people will get rear-ended and get a tap and, oh, I'm so hurt. And, that I knew that happened, but I had no idea that like 3 cars would go out and purposely like try to get a car to hit them so that it, terrible.
Yeah.
No wonder our rates are so high. That is one thing I did notice when I moved to Oregon. I couldn't believe how much cheaper my car insurance was. And I don't know if it's the whole state of Oregon or just because we were in Bend. So it was a small town, but they did say that it's because there's not a lot of traffic. So then your
number of cars is just immense. I can't even believe these days, like driving somewhere in the middle of the day, I'm at home, I have at school. I'm like, why are all you other people not working? Why are you on the roads?
I know it is. It doesn't even matter anymore, like what the time is. Because I know you're in San Diego area, but where are you at, Catherine?
I'm just outside of Nashville, but
okay.
I'm a Southern California born and raised. I've only been here about 5 years, so I know how it is in LA. That's where I'm near. I was near.
Yeah. So. Yeah. So it doesn't even matter anymore if it's rush hour traffic. It's just I remember not too long ago, we went to see my daughter and we left at like 3 a.m. and we still hit traffic. And I thought, where are all these people going?
Yeah.
It's just crazy. So, yeah. So that definitely was an eye opener for me when I read that and realized that there's actual cars out there that are trying to get you to hit them,
Yeah.
So,
yeah.
Well, you guys, thank you for being here live and have a great weekend.
Thank you.
See you Wednesday. It's nice to have the 2 classes.
Yes, I know. I'm so excited. So don't forget, next week we'll have 2 classes for each speed. So low, the lower, the mid, and the high. So I know it's nice. So, all right. Well, have a great weekend and I will see you soon.
All right. Bye.
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 Bye.